buying a home, maybe some land. It's probably one of the biggest decisions you'll ever make, financially and personally.
Absolutely huge.
And, usually right near the start of that whole process, you sit down with a real estate broker, someone who's supposed to guide you.
Mm-hmm.
And part of that involves signing an agreement, right?
Yeah.
A contract about how you'll work together. But be honest, how often do we really understand what we're signing there?
That's the question, isn't it? People are often eager to just get started.
Welcome back to the deep dive. Today we are pulling back the curtain on a really fundamental document for buyers, the exclusive right to buy listing contract.
Yep.
We're going to use a pretty standard fillable form as our example, one approved by the Colorado Real Estate Commission.
A good representative example.
So our mission today, let's unpack this thing. We'll cut through the jargon, pull out the absolute must-knows, the key terms, your rights, your obligations, and maybe the big one for a lot of folks, exactly how your broker gets paid. Think of this as your essential heads up, your shortcut to getting informed before you sign anything.
And it's so important to frame this correctly from the get-go. This isn't just like a welcome packet.
Oh.
As the form itself points out, it's a legally binding contract. Big consequences. It actually strongly recommends you talk to legal and tax advisors before signing.
That's good advice.
And another really critical point right there in the form, broker compensation. It's not set by law. Completely negotiable between you and the brokerage firm.
Fully negotiable. Okay, that's a huge point right up front. So let's dive in. What exactly is this document?
Okay, so at its core, this contract sets up an exclusive, irrevocable agreement. That means you're agreeing to work solely with this brokerage firm for a set period.
Exclusive.
Okay, it's between you, the buyer, and the brokerage firm, which acts through a specific named broker. And it outlines the services they'll provide, finding property, negotiating, helping you buy, or maybe even lease. And crucially, how they earn their compensation for that work.
Got it. And the contract defines these players, right? Buyer, brokerage firm, broker.
Yes, exactly. Buyer is you. Brokerage firm is the company, the licensed entity. And the broker is the individual licensee affiliated with that firm who's actually working with you day to day.
Okay.
The contract might note slight differences if it's a big firm versus a one-person shop, but functionally, the broker is your main point of contact.
And what about the property? Is it just houses or?
No, it's broader than that. It's defined as real estate that substantially meets the requirements you lay out, or basically any property you find acceptable and decide to pursue.
So pretty flexible.
Yeah, and it's not just about buying either. There's usually an option to check if the broker will also help you negotiate a lease. So finding a rental could be covered too.
Interesting.
And the definition of purchase itself is broad. It covers getting any interest in a property. So signing a contract to buy, signing a lease, even acquiring ownership in, say, an LLC that owns the property.
Okay. Covers a lot of ground. How long does this agreement usually last? What's the time frame?
That's determined by the listing period. You agree on a specific start date, and it runs until one of two things happens. Either you successfully complete the purchase or lease of a property, or you reach a specific end date you've agreed upon in the contract, whichever comes first.
And can you extend it?
Yep, you can extend it with a written agreement. And even if the main period ends, the broker might still have some duties or rights to compensation related to a deal that was already in motion.
Gotcha. And there was a quick technical point about how time is calculated, like what's a day?
Right, a small but potentially important detail. A day is a full calendar day, ending at 11:59 p.m. Mountain Time, since this is a Colorado form.
Okay.
And when you count periods like within 10 days, you don't count day one, but you do count the last day. There's also usually a checkbox about deadlines falling on weekends or holidays, whether they push to the next business day or stay put.
All right, details matter. Now, here's where I think it gets really crucial for buyers, something you need to understand right from the start. This contract offers different types of relationships with your broker, doesn't it?
Absolutely. This is fundamental. Right near the top of the form, there will typically be checkboxes for different brokerage relationships.
Like buyer agency.
Exactly. If buyer agency is checked, your broker is acting as your limited agent, your buyer's agent. Think of this as the traditional agent role. They have specific duties to you.
Okay, an agent working for me, what's the other main option?
The other common one is transaction brokerage. If that box is checked, or sometimes if neither box is checked, the broker acts as a transaction broker.
And if neither is checked, it defaults to transaction broker.
That's often the case according to the form's language, yes. Transaction brokerage becomes the default relationship.
So let's break that down. What's the real practical difference between having a buyer's agent versus a transaction broker helping you?
The fundamental difference, well, it really boils down to advocacy.
Advocacy.
Yes, a buyer's agent is your advocate. The contract says they promote your interests with loyalty. They're on your side. A transaction broker, on the other hand, is neutral. They facilitate the deal, but they aren't an advocate for either party, not you, not the seller.
More like a referee or a coordinator.
Sort of, yeah. They manage the process, provide information, handle paperwork, but without that duty of loyalty specifically to you or the seller, they're facilitating the transaction itself.
Okay, big difference in role. The contract also talks about in-company transactions, right? Like, what if the seller's broker works for the same company as my broker?
Right, that happens all the time.
Yeah.
The contract explains this. If you have broker A from firm X representing you, and broker B from the same firm X represents the seller,
Yeah.
they generally just keep their original roles.
So my buyer's agent stays my buyer's agent.
Usually, yes.
Yeah.
And the seller's agent stays their agent. You just acknowledge the firm might get paid from both sides.
But what if it's the same individual broker who somehow ends up involved with both me and the seller on the same deal? That seems tricky.
It can be, but the contract lays out rules, and it depends heavily on that initial choice you made, buyer agent or transaction broker.
Okay, how so?
If you chose buyer agency initially, the default setup is your broker continues as your buyer's agent, but they treat the seller as a customer, basically working with them but not for them.
So still loyal to me.
Right. However, there's a catch. If that broker gives you a written change of status notice saying they've now also formed a relationship with the seller, they must switch to being a transaction broker for both of you, neutral facilitator again.
Ah.
There's also usually a box you can check up front in the buyer agency section that says essentially, no, under no circumstances can you switch. If you work with the seller, you must remain my buyer's agent only.
Giving the buyer control there. And what if I started as a transaction broker?
If you start with transaction brokerage, it's simpler. The contract usually says your broker remains a transaction broker for you. If they also work with the seller on that same deal, they just act as a transaction broker for both parties. Keeps that neutral role consistent.
So that initial checkbox really shapes how things play out, especially in those potential dual situations. It's not just a minor detail.
Not at all. It defines the core relationship and duties.
Okay, let's move on to those duties. Brokerage duties. Regardless of whether they're an agent or a transaction broker, what does the contract say the broker absolutely has to do for you? These are the baseline, right?
Exactly. These are the uniform duties. They apply no matter what. First and foremost, they have to exercise reasonable skill and care in their work.
Which means, what does that look like practically?
Well, the contract lists specifics. Performing the terms of your agreement, doing what they said they'd do, timely presenting all offers and counteroffers even if you're already under contract elsewhere.
Okay.
Crucially, disclosing adverse material facts about the property or the transaction that the broker actually knows.
Adverse material facts actually known. That qualifier seems important.
It is. It's not what they should have known or could have found out, but what they have actual knowledge of. They also have to advise you to get expert advice when matters are beyond their expertise. Legal, tax, inspections, environmental issues, things like that.
Makes sense. They aren't experts in everything.
Right. And they have duties for timely accounting of any money or property they handle for you and keeping you fully informed about the transaction's progress.
What about confidentiality? That seems vital. What are they forbidden from telling others about me?
Super important. Without your informed consent, they cannot disclose things like, well, your willingness to pay more than you offered, or accept financing terms different from what's on the table.
Your bottom line, basically.
Exactly. Or your motivations for buying or any other confidential information about you, unless, the law requires it or not disclosing it, would be fraud.
Okay.
You do implicitly consent to them sharing necessary info with their supervising broker within the firm. That's standard oversight.
And what are they allowed to do? Can my broker show the same house I love to another one of their clients?
Yes. The contract is very clear on this.
Yeah.
Your broker is allowed to show properties you're interested to other potential buyers. They can even help competing buyers make offers on the same property.
Wow. Okay. So they aren't exclusively tied to my interest in that one property.
Correct. It doesn't violate their duty to you.
Right.
Also, if you go under contract to buy or lease a place, they generally aren't obligated to keep searching for other properties for you unless you've made a separate agreement about that.
Now, you mentioned those limits, adverse material facts actually known. This next part about the limits on the broker's duties feels like something every buyer needs to really internalize.
Absolutely critical. This section manages expectations. The contract explicitly states the broker has no duty to conduct an independent inspection of the property for you.
They won't check the foundation themselves.
No. And they have no duty to independently verify the accuracy or completeness of statements made by the seller or the seller's broker or even the independent inspectors you hire.
So, if the seller says the roof is new or the inspector misses something, the broker isn't on the hook for verifying that.
According to this standard contract language, no.
Yeah.
The responsibility for due diligence, getting inspections, verifying information, rests firmly with you, the buyer.
That's a really important distinction.
It is.
Okay.
And similarly, the contract says they have no duty to investigate your financial situation or verify the accuracy of what you tell them about your ability to buy.
Okay, so they guide and facilitate, but they aren't warranting the condition of the house or my bank account. Diligence is key for the buyer.
Precisely. But there is a flip side regarding disclosure. Your broker does have a duty to disclose adverse material facts they actually know about you to the prospective seller,
Like what?
like issues regarding your financial ability to actually close the deal, or maybe whether you truly intend to occupy the property as your main residence if that's relevant.
Got it. And just for peace of mind, the contract usually says you aren't liable for your broker's mistakes unless you told them to do it, right?
Correct. You're generally not liable for their acts or omissions unless you approved, directed, or ratified them.
Okay. Now, if you did check that buyer agency box earlier, you mentioned additional duties.
Yeah.
What extra responsibilities does a buyer's agent have?
This is where that advocacy role really comes in. The additional duties for a buyer's agent include promoting your interests with the utmost good faith, loyalty, and fidelity. Strong words there.
Yeah.
They must actively seek a price and terms for the property that are acceptable to you. And they need to counsel you on material benefits or risks of a potential transaction that they, again, actually know.
So more proactive advice and negotiation support.
Exactly. It moves beyond just processing the deal to actively looking out for your best interests within the bounds of their expertise and knowledge.
All right, let's shift gears to the topic everyone's usually very interested in. Compensation. How does the broker actually get paid?
Yes, the money section. It's detailed,
Uh-huh.
and you really need to understand it. This part outlines how the brokerage firm, remember, the fee goes to the firm, not the individual broker, directly earns its compensation.
Okay.
It notes there's no discount just because you found the house yourself or did some legwork.
Makes sense. It's an exclusive agreement.
Right. And importantly, unless you agree otherwise in writing, the firm can't accept extra bonuses or incentives from the seller or the seller's broker.
Good transparency. So what's the standard way they get paid for a purchase?
The most common method is the success fee. This is usually stated as either a percentage of the final purchase price or maybe a flat dollar amount. You agree on this up front.
And when is that fee considered earned versus when is it actually payable? That timing can be confusing.
Good question. The contract typically says the success fee is earned by the firm as soon as a purchase occurs, meaning essentially when you enter into a binding contract to buy the property.
Okay. Earned when the deal is made.
Right. But it's usually payable at the closing when the property actually changes hands.
Got it. What if the deal falls apart before closing? Does the broker still get paid?
The tricky part. The contract addresses this. If the transaction fails only because the seller defaults, and it wasn't your fault at all, then that earned success fee is typically waived. You don't owe it.
Okay, fair enough.
However, if the transaction fails, even partially because of your default as the buyer, maybe you back out improperly or can't get financing you weren't contingent on, then the success fee is not waived.
Oh,
It becomes due and payable upon your default, generally no later than the original closing date was supposed to be.
so defaulting as a buyer can be expensive beyond losing earnest money. You might still owe the full commission.
Potentially, yes. That's a major point to understand.
Are there other ways brokers get paid besides that success fee?
Yes, the contract allows for flexibility. You might agree to an hourly fee for the broker's time, or maybe a retainer fee paid up front.
A retainer. Is it refundable?
It depends on what you negotiate. The contract usually specifies whether the retainer is non-refundable or if it gets credited towards any success fee earned later.
Okay. And what if you're using this contract to find a lease, not buy?
If leasing is checked, there's a separate compensation section for that. The fee might be based on square footage or a flat amount. It's typically earned when the lease is signed by everyone.
And paid when?
Often maybe half upon signing, half when you actually get possession of the property. And you might also agree on fees if you later extend or renew the lease or expand the space.
Gotcha. Now, this next bit feels like the absolute hot topic right now regarding these contracts. Who will pay the brokerage firm's success fee? This seems critical.
It is absolutely critical, especially with recent industry discussions. The contract usually presents options.
What's the default if you don't check a specific box?
The common default language often authorizes the broker to first seek payment from the seller's brokerage firm or the seller directly. This is the traditional model many people expect.
Okay, so they asked the seller side first.
Yes. And this is the crucial part of that default setup. The language then typically states that you, the buyer, are obligated to pay any amount of the agreed-upon success fee that is not paid by the seller or the seller's broker.
Whoa, wait. So even in the normal scenario, I could be on the hook if the seller doesn't cover my broker's full commission.
Under that default language, yes, that obligation is written in. However, there's a vital protection for you built in.
Okay.
Your obligation to pay that shortfall only applies if your broker discloses to you, in writing, the specific amount you would potentially have to pay. And they must give you this written disclosure before you sign the contract to buy the property from the seller.
So they have to give me a clear heads up in writing about exactly what I might owe before I commit to buying the house.
Precisely. If they don't provide that specific written disclosure prior to you signing the purchase agreement, your obligation to cover that potential difference basically disappears. It's a huge buyer protection.
That is a massive detail. So what's the alternative option to that default?
The alternative is usually clear checkbox stating buyer will pay. If you check this box, you are explicitly agreeing up front that you will pay the entire success fee directly.
No looking to the seller at all.
Correct. And if you choose this option, the contract usually forbids your brokerage firm from also accepting compensation from the seller or their broker unless you specifically agree to it separately in writing.
Okay, understanding those two payment structures, and especially that disclosure requirement in the default scenario, seems absolutely fundamental before making any offers.
It really is. It lets you know your potential financial obligation clearly.
Let's talk about something called the holdover period. Sounds a bit legalese, but I gather it's important.
It is. It's mainly a protection for the broker's efforts. Essentially, the holdover period means you might still owe the success fee even after your exclusive agreement with the broker expires.
How does that work? If the contract is over, it's over, right?
Not quite, potentially. You might owe the fee if, within a certain number of days after the contract ends, the holdover period, maybe 30, 60, 90 days it's specified, you end up signing a contract to buy or lease a property that falls into a specific category.
What category? Any property.
No, only what the contract calls a submitted property. That means it has to be a property that your broker negotiated on for you during the original contract term, and critically, the broker must have given you the address or description of that property in writing during the contract term.
Okay, so only properties they actively worked on and documented with me in writing, not just any house I look at later.
Correct. It ties back to their specific work during the agreement.
Is there a way out of paying that holdover fee if I do end up buying one of those submitted properties later with a different broker?
Yes, there's usually a key exception, often controlled by another checkbox. You generally won't owe the fee to your original broker for a submitted property during the holdover period if you enter into a new exclusive agreement with a different brokerage firm during that holdover period, and it's that new firm that helps you buy that specific submitted property.
Okay. So if I formally hire a new exclusive broker within that holdover window and they help me buy the house my old broker showed me, I pay the new broker, not the old one. Prevents double dipping.
Exactly. It allows buyers to move on cleanly to a new exclusive relationship without facing double commission claims on the same property. And interestingly, the form often states that if no box is checked in this specific holdover section, the default is that you do not owe a fee during the holdover period.
That's good to know. The default seems buyer-friendly there if left blank. And one last point on money. Limitation on third-party compensation.
Right, this is about transparency. It generally says your brokerage firm can't accept other fees or kickbacks from third parties involved in your transaction, like lenders or title companies, without your written consent.
Okay.
And they can't mark up the cost of services from outside vendors or affiliated businesses and profit from that markup, again, unless you've explicitly agreed to it in writing.
All right, that covers the broker side pretty thoroughly. What about my obligations as the buyer under this contract?
Your main obligation lines up with the exclusive part of the agreement. You agree to conduct all your negotiations for property only through your designated broker during the contract term.
So I can't call the listing agent directly or try to talk to a seller myself.
Correct. You agree to refer all communications from sellers, other brokers, anyone about potential properties directly to your broker. Let them handle it. You also have to state truthfully whether you're currently under contract with another broker or if you've received a submitted property list from a recently expired contract.
Honesty about existing relationships. What if someone doesn't follow the rules? What does the default section say?
It cuts both ways. If your broker or brokerage firm substantially fails to perform their duties, you typically have the right to terminate the contract.
Okay.
Conversely, if you substantially fail to perform your obligations, and that includes failing to reasonably cooperate with your broker, then the brokerage firm can terminate the contract by giving you written notice.
And if they terminate because I defaulted?
Then any rights they had already accrued before termination survive. This could include the right to seek damages, potentially covering their costs, or even the commission they would have earned if you hadn't defaulted.
Right. Ties back to that success fee possibly being due on buyer default. What about costs for things like inspections or appraisals?
The contract clarifies that you, the buyer, are responsible for paying for services or products you order from outside sources, surveys, inspections, tests, etc., assuming you agreed to pay for them. Your broker isn't obligated to pay these for you up front.
But they might arrange them.
They might help arrange them, yes. And if they do advance funds for a service you authorized, you're obligated to reimburse them promptly.
Okay. Beyond these big sections, the contract usually has a lot of other acknowledgments and clauses, doesn't it? Stuff that might seem like boilerplate.
Yeah, but some of it is quite important context. For example, you'll likely acknowledge that the broker explained how property showings work and any limitations. There's often a clause about disclosing your identity. You need to give permission, usually via a checkbox, if you're okay with them telling third parties who you are without asking each time.
Privacy settings, kinda?
Sorta, yeah.
Yeah.
You also acknowledge that costs and quality can vary wildly between different service providers like lenders, inspectors, title companies. You need to choose wisely.
And I noticed some things that seem very current, very 21st century.
Definitely. There's almost always a strong warning now about wire fraud. Urging extreme caution with wiring instructions, advising secure methods like in-person delivery, it's a huge risk area. There's also usually a clause acknowledging that online marketing material photos, videos of properties, can be almost impossible to fully scrub from the internet later, and you release the broker from liability if they can't get something removed.
That online content issue is real once it's out there.
It's out there. Other standard clauses include non-discrimination. The broker must follow fair housing laws. It repeats the advice to get legal and tax counsel before signing. Can't say that enough.
What happens if there's a dispute later on between me and the broker? Do we go straight to court?
Usually not. Most contracts now require mediation first for any dispute arising from the agreement.
Mediation, how does that work?
It's a less formal process where a neutral third-party mediator helps you and the brokerage firm try to reach a mutually agreeable settlement. It's confidential and non-binding. The mediator doesn't impose a decision, but you have to try it in good faith before escalating. You typically share the cost of the mediator.
And if mediation fails?
Then you might proceed to arbitration or court, depending on what the contract says or what you agree to. And usually the contract states that the winning party in any subsequent arbitration or litigation gets awarded their reasonable costs and attorney fees.
Good to know. It also mentions sections for additional provisions and attachments.
Right. That's where you can add custom terms you negotiate that aren't in the standard form or attach relevant addenda or documents.
And standard legal stuff, like it's governed by state law, Colorado in this case, changes must be in writing, and this written contract is the entire agreement.
Yes, all standard contract points. Supersedes any verbal chats you had before signing. And one last specific acknowledgement that often appears.
Let me guess. Megan's Law?
You got it. There's usually a specific notice stating that if the presence of registered sex offenders near a property is a concern for you, it is your responsibility to contact local law enforcement agencies to get that information. It explicitly states the broker does not have a duty to research or disclose this.
Another area where the onus is clearly on the buyer for specific concerns.
It's exactly.
Okay, wow. We've covered a lot of ground, unpacked a lot of clauses. So, stepping back, what does all this really mean for you, the buyer, looking at this document?
It means this contract is way more than just hiring someone to unlock doors. It is the legal foundation of your entire working relationship. It sets clear expectations what your broker will do, what they won't do, and what you need to do.
Yeah, defining those roles and limits seems key.
And it clarifies the different ways a broker can represent you, that crucial difference between an agent who advocates for you and a transaction broker who facilitates neutrally. Understanding that choice is huge.
And the money, of course.
Absolutely. How compensation is structured, when it's earned, when it's payable, who is expected to pay it, especially understanding that potential buyer obligation and the critical written disclosure requirement and those holdover period rules. These aren't minor details. They're central to the agreement. Plus, recognizing the explicit limits on the broker's duties, like not being your inspector or financial verifier, really underscores where your own active involvement and due diligence are absolutely essential.
So understanding this document really empowers you as a buyer, doesn't it? Helps you ask the right questions, know what to expect, maybe even negotiate terms.
Totally. It's about walking into one of life's biggest transactions, not just with excitement, but with clarity, and your eyes wide open to the rules of engagement you're agreeing to.
So here's something to think about as we wrap up.
Mhm.
Given all these specifics we've just pulled apart, the nuances of representation, those clear limits on what a broker is obligated to inspect or verify, the different ways compensation works, who might pay it, those holdover rules. How does really understanding the fine print of this agreement change things for you? Does knowing these contractual details make you think differently about how you'd select a real estate professional or how you'd interact with them compared to maybe just looking for someone friendly to show you around?